So, this was a question of, membership eligibility for the BZA and the planning board. And, it was brought to my attention by,
Ben Bowling.
Ben Bowling. He said, we was talking to him about the planning commission, and, he said that his neighbor was Mark, and I, well, I didn't realize that, but I checked him to see if he met the requirements here, but because we did the same thing with Anthony Cypher when he, stepped up to an elected position, and he was no longer eligible to be a citizen member at that time. So we went and looked, to see what was there, but in, as far as the BZA in, 36-7-4-905 said you have to either own property or reside within the jurisdictional limits of the board. And the same thing applies for the, planning commission. And the only thing is, about 10 or 11 years ago, Drew Wright come in front of the, commission at the time, planning commission at the time, and they signed the rights away to the city of Salem for the jurisdictional limits of the 2 mile fringe, which is, so therefore the county can't say that, or the way I'm reading it, we can't claim the 2 mile fringe as being part of the jurisdictional limits that either of these boards have. And that was the issue, but, pretty much in a nutshell, it's up to the board to decide where you're at and what's, going on. But I mean, the state has other things, you can only have 3 people of the same political party, and you can only have, there are different things that goes into this, and it's a pain if you don't read the book, but the question being, down the road, do you get caught? And somebody said they didn't have due process because you didn't have totally legal members all the way around. And if the board's okay, we'll take it. And the thing is too, that we've had a hard time keeping a quorum in to do a lot of things. And, I have no problem with Mark. I have no, read, just like the same with Anthony Cyphers. I mean, once he wasn't a qualified member, does it actually hurt the board worse than help? Even though you have good input and good things to say, will it be a deterrent down the road when somebody, decides they don't like these ordinances and want to put together that they wasn't, completely above board when they was established? So, that's it, I'm done, it's up to the board that, the concern come up, and the same thing with when Anthony Cyphers, when it come up, but, that was it, and the way I'm reading it, the 2 mile fringe is not our, the BZA does not have the right to grant anything in the 2 mile fringe, and neither will the board when you draw your map and say we have a 20 acre minimum, it would not apply to the 2 mile fringe, so. Anyway, thank you. Sorry to be the bearer of bad news, but that's, any questions?
Does anybody have any questions?
I mean, that's the two things.
There are. I spent quite a bit of time looking at this. The planning commission.
Could you speak in the microphone, John?
The planning commission and the BZA have jurisdictional authority over roads and streets. That overlaps the 2 mile fringe. So the statute does not define which jurisdictional authority applies. Okay? It says over the area over which the commission has jurisdictional authority. Well, the very example is that resolution that was passed back in 2021 regarding setback. That applies to county roads and streets part of which are within the 2 mile fringe. And that's a jurisdictional matter, that the Plan Commission and the BZA, exercise authority over. So it's my opinion that there really isn't an issue involved. And it's something that down the road, maybe some legal experts gonna jump up and feel something, okay?
Well, but the question being like the 60-foot setback, we could give a variance, but we can't give one for in a 2 mile range.
I think you can.
No.
You think we can? Then any question that comes up to the city, they have to defer to us on the road setback distance?
The city ordinances on subdivisions take precedence in the fringe, but jurisdiction on the county, the city does not control the county roadway. The city's not out here blacktopping roads in the fringe all the time. Todd, the city's not blacktopping roads in the fringe.
No. No,
No, county's
I
black.
wish they would. What's confusing is we have overlapping areas of responsibility. I think some of us are confusing those overlapping areas of responsibility as far as jurisdictional control over whether a board member is eligible to sit on the board. And if you read the first 2 pages of the latest ordinance that addresses this, 2010-05, I can see where it might be a little bit confusing. But the bottom line is, if you go to page 3, that defines the qualifications of a board member for the County Plan Commission, it clearly states a resident of an unincorporated area of the county. The fringe is an unincorporated area of the county, period. That's what it says. I don't know how much simpler it could get. On page 3.
Pretty simple, maybe.
Well, that's fair enough. It's, I'm reading it the same way I read it when we talked to Anthony, when he actually picked up an elected position. We was told that it said you couldn't hold as a citizen.
That's a totally different
Hold it.
subject.
Yeah, but you're correct,
And if you'd like more
that's.
more proof, there's a short paragraph here, I'll just read it to you. This is from the state, it's Indiana Code 36-7-4-211, membership of commission. Notwithstanding any other provision of an area planning law, the representation on any area plan commission may be changed by a similar ordinance adopted by the legislative body of each unit, in this case the county, that is a participant, key word here, that is a participant in a planning department or by the legislative body of each unit that proposes to form a planning department. In other words, the state of Indiana is giving counties, in this rare case, flexibility to do as they see fit. And that's what happened in 2010 in ordinance 2010-05.
Fair enough.